Hi, good afternoon everyone. This is Rajiv S. Khanna from immigration.com, the law office of Rajiv S. Khanna PC. Today is January 12th, 2017, our first community conference call of this year. We have these calls every other Thursday. You're all welcome to post your questions and attend. Time permitting, we'll take new questions. If not, we will definitely cover the ones that have been posted, of course. You've heard the disclaimers. This is an information session only. It is not intended to create an attorney-client relationship. It is also not a substitute for a one-on-one consultation. Okay, let me get started with the frequently asked questions first. By the way, please follow us on Twitter, Facebook, Google+, social media. The links are on our homepage, immigration.com, right on the very top. That said, I'm also monitoring my Twitter account. If there's something you want to tweet to me, I can attend to it, of course. Let's begin with questions that I have marked as frequently asked questions. The first set of frequently asked questions deals with new regulations that affect I-140, H1, the ones that are coming in effect from January 17th. I did create on my blog, I'm sure many of you would have actually seen that. We created a infographic that's actually my notes. There are a couple of typos in there, not a big deal, but I hate to see shoddy work. However, this was done during the holidays, so I was the only one reviewing it. The graphic actually contains the entire regulation, EB I-140 regulation, in a nutshell. These are my notes. I actually go back to these regulation graphics and myself refresh my memory through those. Might be a good idea to open them from immigration.com. Look at the bottom right hand side, and the right hand panel has link to my blogs, and also the top panel has a link to my blog. When you open that, you'll see the I-140 regulations link. Open the graphic, and that will give you a good guidance, I hope, on what the new changes are. That said, let's go to the frequently asked questions. I have merged 2 or 3 posts that were asking similar questions. So the first question is, on the I-140 rule, how does the 180-day calculation work? And the way I understand it is this. If your I-140 was pending for 170 days, on January 17th, you just need 10 more days. In other words, the 180 days don't have to be accumulated after January 17th. That's the way I see the regulation. Unless USCIS comes and tells me that this is not the way the regulation was meant to be interpreted, I would go with this observation that as long as it was 180 days somewhere after January 17th, you'll be covered. Of course, if your 180 days are over already before January 17th, then you are automatically covered on January 17th. I hope that part is clear. So then this question, I don't know who posted these questions, they came through Monica. So he goes on to say that, let me explain my question further. I am on H-1B visa for 5 years and 3 months completed. My H-1B extension is filed on November 2016. I-140 is approved in 2013. Priority date is also 2013. If company revokes H-1B and I-140 on 30th July, see, by that time 180 days are pending. I don't think you have anything to worry about. I transferred to a new company, then I have to go to India in March 2018. I have old I-140 which was approved but revoked. Can company use my old H-1B and extend it for 3 years? Yes. Yes, they can. And you will not be subject to the cap. In fact, another situation is, in Feb 2017, I joined new company and my H-1B extension is still in process. New employer will transfer my H-1B, but can they file my H-1B extension immediately? Yes, they can. This is an issue of status rather than of the extendability of the H-1. Your right to extend your H1 is coming from your I-140. Once it's pending 180 days, even if the old employer revokes it, your right to keep your priority date as well as extend your H1 through any employer remains inviolate. That right is not taken away. Okay. The second part, which is status, that's a little bit more complicated. So when you have a series of H1s filed, let's say there is employer X, Y, and Z. You have an extension pending from employer X. You have a transfer pending from employer Y, also a transfer pending from Z. In these cases, when there is a chain H1 application, it can be a problem if the following circumstances occur. Let me modify the hypothetical just a little bit. XYZ, three employers. X has filed extension. While the extension was pending, using AC-21 portability, while your current I-94 was still valid, you joined employer Y. And while the transfer with employer Y is pending, you filed with employer Z. Original I-94 expired after you joined Y. So now you don't have status because your I-94 has expired, but you're allowed to continue working for employer A because you used AC-21 portability. You transferred from X to Y. Now what if you want to go from Y to Z? Your I-94 has expired, because if I-94 was not expired, you would be covered by the original H1. It's merely a simple transfer. There's no chain. But when there is a chain, if any link in the chain fails, H1 can still be approved, but you have to go outside USA for visa stamping. That's all. It's not the end of the world. I'll open the floor for questions, but let me finish another merged question. This one is from PW. I'm currently with employer A. I-140 was approved in June 2016. So he wants me to confirm his understanding. Because his I-140 was approved more than 180 days ago on January 17th, he will retain his priority date. Yes, you will. Retain the right to extend H1B 3 years at a time even if the I-140 is revoked. Yes, you will. Need to get the green card process started again. Beautiful. That is exactly right. Second set of questions they have is, will my spouse have the option to get H-4 EAD through my current I-140? You see, I don't think it works like that. Remember, the H-4 EAD rules came out before this rule comes out. So there may be some confusion because of the timing of the three sets of rules that we are looking at. But the way I see it, in order for H-4 EAD to be filed, there must be one I-140 remaining. If the I-140 is, again, I could be wrong about this. I haven't looked at the regulation from this angle. Next time when I review the regulations, I'll keep this in mind. But my preliminary thought is, under the H-4 EAD regulations, the regulations that came earlier, if there is no I-140 outstanding or surviving, you can't get H-4 EAD. There's got to be one I-140 surviving. This rule that preserves your right to carry your date as well as after 180 days, carry the right to extend your H1 beyond 6 years through any employer is unique to you as the H1 holder. It does not spill over as an H-4 EAD benefit to your spouse. That's the way I see the regulations. The last set of questions in the same series is, my priority date is Jan 2013. I-140 approved more than 2 years. H-1B is under 8 years and 6 months. An extension is filed. I'm planning to go to India after 17th January and leave present job. Employer said they will revoke the I-140. See, I always hesitate to give a definitive opinion. My view is, after January 17th, if your 180 days are over, you don't have to start a new count from January 17th. Your rights will be preserved as of January 17th. So that's the way I view the regulations. But please, for heaven's sake, before you make that decision, have your lawyers or somebody specifically look at the regulations and make sure my interpretation is correct. Because I have done a bird's eye view of the regulations, and every time somebody asks me a question, I tend to go back and read the regulations again for our clients. Anything I have a doubt about. So I think you'll be safe after January 17th because your I-140 was approved more than 2 years ago. That's my view, but have it double checked. Your new employer will be able to extend your H-1B based upon the old I-140 even though it is revoked. Then you have a couple of questions about EB2 application with I-485 filed and now on EAD. I switched employers a few months ago after 180 days had passed since filing 485. Do I have to file supplement J? The answer is I don't think so. We're still waiting for the final instructions and the final forms to come out. But a person in your situation who has already ported before January 17th should not have to file supplement J. From January 17th onwards, if you port, you will have to file supplement J. And the last question is, does the new EAD filing rules about duration, when to file become effective? I'm not sure I understand that. Does the new EAD filing rules about duration and when to file, become effective immediately on rule becoming active? Yes. Yes. The whole set of regulation and its underlying provisions become effective on January 17th. Okay, folks, any follow-up questions on what I have discussed, press *5. No new questions. Any follow-up questions on what I just discussed? One raised hand from Iowa. Okay. Two, another raised hand from Illinois. 2 hands so far. Okay. Let's go in the order in which you logged in. So, Iowa, go ahead, please. Iowa.
Hi, Rajiv. So on the question by DW,
yes, sir.
There was a part to it that says if the green card process is started again through employer B, but gets rejected at some stage, I think you maybe missed that.
Yeah, I'm sorry. My fault. Let's say that green card. Yeah, the thing is, you don't lose your right to the I-140 extension because you would have the old I-140 still remaining valid. So if your employer B's PERM I-140 gets rejected at any stage, PERM or I-140, because you have a earlier right already secure, the way I see it is that does not get taken away. So you should still have the right to extend your H1 based upon an earlier approved I-140, which was, even though revoked, was revoked after 180 days of approval. Okay?
Okay, that's helpful. Thanks.
You're welcome. Let's go to Illinois. Illinois, go ahead, please.
Thanks, Rajiv ji, for helping us.
Of course.
So, my question, I have a little doubt, like not clear properly. So, my question was actually like when I lose my H1B also revoked and my I-140 is also revoked. Both the things is revoked.
Okay.
And maybe in 2018, if I come back, I try to come back, then it's like I had a 2-year approved I-140, but my H1B was revoked.
Okay, that doesn't matter. That doesn't matter. The revocation of your H1 does not affect your right to future extensions based upon an earlier approved I-140.
So they don't have to go through lottery and all this. They can just use my H1B, old H1B, and extend it.
If see, there are several different regulations at play. The question now that let's focus on the aspect of whether you will need to go through the quota. There is only one issue there. Have you had an H1 approval within the last 6 years? The answer is yes. So no problem. Even if it was revoked, unless it was revoked by the government for certain reasons, revocation by a private employer does not take away your right to be exempt from the H1 quota. Okay?
So I already had like 7 year.
Doesn't matter.
7 year on same H1.
Doesn't matter.
So I'll be safe. Like in 2018, when I'll plan to come back, my employer, anytime I can come if they extend old one.
Yes, that is the way the law reads today. I don't know what happens with the new administration, but whatever happens, we will all have sufficient notice. They cannot change the laws overnight.
Okay, thank you.
You're welcome. Okay. Let's go on to the next set of frequently asked questions. So, how about this case where C. Wade says, and this is also a couple of merged questions. First set of questions is, if my spouse is on H1 and she wants to convert to H4 EAD, if she converts to H4 EAD, can her green card through her own employer still go on? Of course. Of course. It can go on, and if the employer wants to file a new green card after somebody joins on H4 EAD, that is also okay. Can she convert back to H1 because she used to have an H1? The answer is sure. Converting from H4 to H1 is not an issue at all, as long as she's not subject to the quota, and she won't be subject to the quota for 6 years. Okay. So can she maintain her green card priority date with the approved I-140? Of course. Not only that, the employer, if it is the same employer, can continue on to 485 when the dates become current. Can she, she wants to switch from H4 to H1B? Sure. With any employer, if the I-140 is approved, quota issue is laid to rest, is she entitled to another H1 extension? Sure, because the I-140 was approved and stayed approved for 180 days. Let me take the next set of questions posted by somebody else. When I merge these, I can't see the name of who posted. I hope you're on the phone. So let's see. This is, my wife is currently on H1B. We're considering to convert H4 EAD. In current political situation, should I change status? Absolutely. Nothing has changed so far, and Trump's stance, whatever it is, if necessary, she can always go back to H1B, as I just discussed. If he's planning to roll back H4 for EAD through rulemaking process, can they halt pending applications? I don't believe so, because until the rules are changed, the old rules are still in effect. So I don't think they can change. They can affect the pending applications. I don't see how. Remember, under the Constitution of the United States of America, Congress cannot make ex post facto laws, and that prohibition kind of spills into the regulations as well. I haven't really spent a lot of time thinking about it, but I would be surprised if any kind of regulation is suspended without the new regulations being effective. I don't think it can work like that. So I'm not worried about that. Scenario 3, if H4 gets approved with future effective date, this has never been very effective. It's very difficult to, because if you file an H4, you can't ask for a particular date on the EAD as far as I know. And there's no guarantee it will get approved on a certain date. So the future effective date on H4, if you ask for a future effective date on H4, which you can, The problem with that is government will not approve the EAD until the H4 is approved. At least that's what they said in the last meeting of American Immigration Lawyers Association. I don't know what they will do today, but yesterday they had made it clear, or last meeting that they had, that they will not approve an EAD until the H4 is approved. So if you ask for a date in the future, it will be the same. First they'll approve the H4, then whatever time it takes to approve the EAD, they'll take that time. Any questions that you have on the topics I just discussed? No new questions. *5 on your phone, please. *5. Okay? I take it there are no questions? All right. Let's go on to the next frequently asked question. This is about the compelling circumstances EAD. This is a pretty complicated set of facts. Let me rephrase that. Very complicated set of requirements. It takes a little while to figure out what the government is saying. But anyhow, Subbu has asked me a very specific question. Let's see what he says. I have approved I-140 with priority date of June 2011. I don't know why somebody has raised a hand. I thought we were past that point. Okay, let me go back and... New York, how can I help you? New York?
Hello, sir. I was the person who asked about H-4 EAD, the last answer you gave.
Okay.
So you were saying that even if we ask for future effective date, let's say current H-4 processing times are 2 months, and let's say EAD processing is 3 months. If we ask for 5 months in the future as effective date, even the H-4 can be approved in 2 months, right?
Right.
We ask for effective date as 5 months. So would they be starting the process after the 2 months?
No.
That is when H4 got approved with the effective date of 5 months after.
Hang on.
Or would they be starting the process after 5 months?
No.
For EAD?
I think the problem here is this. You can ask for an effective date on the H4 but not on the EAD.
Yeah.
Right? So if you ask for an H4 effective 2 months from today, H4 will get approved. How long the EAD will take, we don't know. It will only begin, the process will begin after the H4 is approved. If you... Yes, after the H4 is approved. So if you ask for an H4 effective 4 months from now, it's the same situation. The EAD will only come into play or process once the H4 is approved. So I'm not sure you can have any predictability in when the EAD will approved, because it simply keeps getting pushed off to after the H4 is approved.
So when you say approved, it's effective date, right? Isn't it?
Yes, effective date. Thank you. Good point.
So
So your question is, yeah, you might have a good point. I didn't think of that. You might have a good point that what if I ask for H4 effective date, let's say the processing time for H4s is 3 months, and I ask for an effective date 5 months from today of the H4, my H4 will be approved in 3 months. And then they should start working on my EAD, thereby bringing me 2 months closer to the approval of the EAD. I think that could work. I haven't ever done it that way, but it should work. It might make the EAD a little bit more predictable. But remember also that government has taken away the 90-day deadline they had imposed upon themselves. They will no longer guarantee approval of an EAD within 90 days.
Okay. But still we can try to mitigate that gap.
Yeah,
you're asking for 5 months or 6 months.
I can't quarrel with the idea that it could work. But again, I don't have any personal experience with it. The team might, but I don't have any personal experience with it off the top of my head. I can't think of a case where we did that. Okay.
Would there be anywhere we can, any old cases where we can get that information from or anything like that, or we wouldn't know?
You can try. This may not work, but you can try calling USCIS and ask to speak with an adjudications officer. Sometimes they let you speak with them. It might take you all day to get through, but it's certainly worth a shot. Like I said, I can't remember ever doing that.
Okay.
All right?
All right, cool.
Good luck.
Thank you.
You're welcome. Going back to our compelling circumstances EAD. So Subbu says, I have an approved I-140 with PD of July 2011 under EB2. I wanted to file I-140 EAD under compelling circumstances or higher promotion basis. I don't know what that means. From current job through current employer. I don't know what that means, Subbu. I hope you're here. After Jan 17th, can I proceed to file the I-140 based EAD? What category is applicable to obtain the I-140 EAD? Complexity, if I change jobs. Amendment to change job. How long is the I-140 EAD valid? 1 year. And is the I-140 EAD renewable? You don't need an employer to renew the I-140 compelling circumstances EAD. Let me give you a quick brief. I won't have time to go over all the details. But if you go to my blog and see the picture I have posted there on the I-140 regulations, here is the compelling circumstances EAD. If you're on E3, H1, H1B1, L1 or O1, or including the grace period, you have to be in status to apply for EAD. And you're the principal beneficiary of an approved I-140 and your dates are not current, you can use compelling circumstances. Difficult situation outside your control. So your I-140 must be approved and the priority dates must not be current. It will be given for 1 year. If you want to get it approved again next year, you have to have some compelling circumstances. The only time an extension does not require compelling circumstances is if your priority date is less than 1 year away. If your priority date is less than 1 year away, you can get a compelling circumstances extension without compelling circumstances. You can't do it in the first instance. You can't say, give me an EAD because my priority date is less than 1 year away. You can't do that. But if you're on compelling circumstances EAD and the next year your priority date is less than 180 days, less than 1 year away, you can ask for an extension of a compelling circumstances EAD without compelling circumstances. Let me check my tweets. Somebody has just tweeted. Raj says, is any place I can get data to HR show that this is not correct information? My company attorney is saying it will take 6 months or more. I'm not sure, Raj, if you're on the phone, what you're talking about. So if you're on the phone, feel free. Okay. Well, I wasn't going to do it right away, but let me see. Compelling circumstances EAD. Raj, hold on 1 second if it's you from Illinois. Just hold on 1 second. Any questions on compelling circumstances EAD, what I have just discussed? Press *5. Any questions on compelling circumstances EAD? Okay. Then let me take Raj. Illinois, go ahead, please. Illinois.
Yeah, sir. My present company attorney is saying that the prevailing wages will take around 6 months or more, and I checked on so many places online, and you also
3 to 4 months. Hang on, let me double check.
This is not a valid menu option.
Sumanji?
Yes.
How long are the prevailing wages for palm taking?
3.5 months minimum.
3.5 months minimum? Thank you.
Okay.
Yeah, that's what I thought. 3 to 4 months is what it's taking right now. Okay?
Yeah, so I think he is just trying to extend those things. So my question was that is any place I can get the data and give it to HR that what attorney is saying is not correct?
You can try the Department of Labor's website, or you can even send them an email. They might have an email address that is exposed to the public on this issue. That's the best I can tell you in the time that I have. But if you look around a little bit, you might be able to find some official documentation. Okay?
Okay, thank you so much.
You're welcome. Good luck. Okay, folks, I don't like to take questions out of turn, but I thought this was something to do with what we were discussing. But that's okay. A couple of minutes here and there is not going to kill us. So let's go to the next set of frequently asked questions. So I actually discussed this, H1 transfer while H1 extension is pending. So I discussed that earlier. I should have combined these questions, but that's okay. So the idea here is, if your I-94 expires during the pendency of a extension and you filed a transfer, and then you filed a second transfer with another employer, because your I-94 has expired, your legality of stay depends upon the earlier pending cases being approved. So anything in the chain, if it fails, you'll have to go outside USA for visa stamping. Not the end of the world. So XYZ, all of them have H1s, whether extension, amendment, or transfers pending for you. If your status depends upon approval of the previous applications, and the previous applications are not approved, any one of them fails, you'll have to go outside for visa stamping. Let me just make sure that's what DD is asking. DD says, my company filed for H1B extension. I'm planning to join my client around March. One extension is already filed. If I join my client, they will first transfer my H1B, then file extension. That's not how it works. You'll file transfer and extension at the same time. How does this process work? So you can join the new company if your status is current. Yeah, because I'm assuming your I-94 is expiring in April and you're joining the client in March. So you can do that, and that way you are still on the original H1. You don't have to worry about the extension. So the best approach is to make sure your H1B is received by the USCIS before your I-94 expires. You can join based upon the receipt, and even if the old employer revokes the I-140, it doesn't bother you. That is the best approach. Join, make sure your next H1 through the client is received by the USCIS before your I-94 expires. Then you're good to join them based upon the receipt, and the old pending H1 does not affect you. Whether it is withdrawn or dismissed, doesn't really matter. Star 5 if you have a follow-up question on this, folks. No new questions. Star 5 for a follow-up question. Okay, I'm going to get started with the other questions other than the frequently asked questions. Let's just see. These two are frequently asked. I dealt with them already. Fly Girl Hannah says, I've got a DUI, applied for citizenship, I'm off probation. I'm wondering if I'll be denied automatically since my DUI was only a year ago. I hear about waiting for 5 years for good moral character. Well, a couple of things you need to remember. There really is no time limit on how far the government can go back in time to look at good moral character. If you have a misdemeanor and you file naturalization, I can't guarantee that your case will go through smoothly. But if government makes a case for makes an issue of it, they may not because it's a misdemeanor, you can definitely submit an explanation and submit evidence of good moral character, and government usually considers it. For example, affidavits from members of the community, from your pastor, from the church, from any good community activities you've been involved with, all of that can help. So you can try filing for naturalization. How does it hurt? They can only deny it. Only make sure that your case is looked at by a lawyer to make sure that your conviction was indeed a misdemeanor and is covered by something called, and you can write this down, petty as in small, P-E-T-T-Y, petty offense exception. Small offense, petty offense exception, which allows you to escape scot-free from one misdemeanor. If you only have one misdemeanor, you should have no problem for your green card. I'm concerned also about your green card. Filing a naturalization is not a problem. Maximum they can say is no. But if you have some more serious issue, your green card can come under a cloud. Okay. Star 5 if you are here and have a follow-up question. Star 5. Okay. Next one is Suresh Doda, age out question. Mr. Doda, when you file a 485, the fact that the child became over 21 after that, I don't think that affects you. I don't think CSPA will create any problems. The only thing which is a little uncertain from what I remember, if you try to convert your application to an EB2, you will have a problem. But as long as you stick under EB3, I'm believing that's what it is, EB3 probably, or whatever your category is, your child is protected by CSPA as far as I know. Star 5 if you have a follow-up question. Okay, the next question is from Fanindra, and I think what he's asking is, can I enter USA when there is only a few days remaining on my visa? And the answer is yes. Technically, even if you have 1 day remaining on your visa, L1, L2, H1, H4, any visa, government has to let you enter. They cannot stop you. I don't see how they can. What type of questions can come? Just based upon your future plans, they can ask you about why you're entering just when a few days remain. Let me double check and make sure that's what you're asking. Having L2 visa, valid EAD expiring in August 2017. I'll go in April, and within the, I'm planning to go to India in August 27. April 17th. Oh, I'll go for renewal in April 17th. Okay, so you're asking for an L2 renewal. So I'm planning to go to India in August 2017. Okay, you cannot enter USA without a new visa. If your visa expires, you'll have to go get another visa stamp. Okay, I'm not sure I followed this question. I thought what you were asking me was a little different. I hope you're on the phone. Press star 5. I'm not entirely clear what your situation is. Star 5 if you are here. Okay, not clear about what the problem is. Usually, if somebody goes outside USA with an L2 extension pending, that extension doesn't matter anymore if your L2 is expired, because you have to go get a visa stamping anyway. Remember, for L2 visas, unlike L1 visas, you don't need a prior approval of USCIS. If your spouse gets L1 extension, you can take a copy of that extension, go apply for an L2 visa and come back. I hope that covers your questions. Next question is about a J1 visa that was messed up in the SEVIS. The responsible officer recommended her to travel and apply for a J1 visa in India. She got a new J1 visa. SEVIS was rendered inactive because her I-539 was denied, but she had already come back with a new visa. Okay, now this is a situation in which a SEVIS correction should be possible, because what has happened is she had a pending J1 I-539, but she actually went and got a J1 visa. That 539 is automatically abandoned. The fact that it was denied is not a problem. But what is the problem is the fact that her SEVIS was made inactive. And that appears to be an error. That should be very easy to correct through a data correction. So contact your responsible officer. I don't think there's any unlawful presence issue here, because I'm assuming that when she entered USA on a new J1 visa, she had an I-94 that covers her as the either duration of status or a certain period of time beyond 2016. So I think she should be okay. I don't see any unlawful presence issue. I hope you are here. We can talk about it a little bit. She's planning to travel back to India. Can they do an H1B? Yes, of course. Can she come back to USA on a J2 dependent? I'm on a J1 visa. We're getting married. as long as there is no unlawful presence issue and there is no 214B kind of imputation that you want to stay in USA permanently, she can come back on J2. I hope you are here. Press *5 on your phone if you're here. Okay, very good. Excellent. Go ahead. I can hear you. Go ahead, please.
Yes. So regarding the update on the SEVIS, so the responsible officer is saying that they're out of the window. So they said there is a 270 days window within which they can update the SEVIS, so they're out of that window, so they can't update the SEVIS record from inactive to active. That's one thing.
How many days did you say? How many days?
I mean, they said, the responsible officer said there is a 270 days window right from the point in time it showed inactive, which was back in February, but she only came to know this December. So they're out of that window to actually update the SEVIS. You
could call SEVIP people yourself and ask them this question. Okay. I'm not an expert in doing SEVIS corrections. That's not my field. That's not my job. But it doesn't hurt to check with SEVIP. Make sure they are telling you the truth. They could be mistaken.
All right.
That's one part. And, go on to the next. Yeah.
Okay.
How about her I-94? How about her I-94?
I-94 is still valid because from the point in time she entered the US, her I-94 is the original practice is still valid.
There is a memorandum, a 52-page memorandum from USCIS on unlawful presence. I'm pretty sure F1 and J1 are covered by the same provision. As long as your I-94 is valid, we don't care what else happens. You're not accruing unlawful presence.
That's true.
Unless USCIS tells you you are unlawfully present. Okay? And
that's indeed true. I'm aware of this. I'm aware of the memorandum.
Right.
It's dated back, I guess, in 1990s.
Right.
So I'm aware of the memorandum because I've been researching quite a bit about this.
Unlawful presence does not look like an issue here.
Yeah, that is indeed true. And about the J1, J2 thing, is it possible that is J2J flipping allowed?
I'm sorry, can she get a J2? Is that what you just asked me?
Yes, my fourth question about is...
Yeah, I think so. I think so. Why not?
Mm-hmm.
Why not? Because let's see. Does her J1 have a home residency requirement?
My J1 has a home residency requirement, her doesn't have.
Okay, now remember, if she can come under J2 as long as they don't impute any intention to become an immigrant in the USA to her. See, the only difference between the time she got her J1 and she'll go to J2 is she now has her spouse in USA. Normally, that should not be a problem. I don't think it's by itself indicative of permanent resident intent, but you never know with the consulates. I personally feel she should be able to get her J2. Technically, yes, she can get a J2 and enter USA, no question.
Right. Okay. Thank you so much.
Okay?
Thanks so much.
You're welcome.
Thanks.
Good luck.
Thanks. Bye.
Bye-bye. Okay. Then we go on to this question where Kelly has asked me certain things, and one of our moderators very kindly pointed out that, look, we need more information. And I'm confused. Kelly, I hope you're on the phone. Press *5 if you are. Kelly, if you're on the phone, press *5. Okay. I looked at this case, wasn't sure what exactly was going on. It looks like there was an I-130 that was pending and got abandoned after 3 odd years. Is there a penalty of $310? Ma'am, I really don't know what's going on. I'm assuming your husband is a US citizen. I'm assuming that. I don't have it correct right there from your question. If he is indeed a US citizen, he should just file a new set of papers, because reviving that old I-130 would be so complicated. It might work, but it could take a lot more time than is necessary. So paying the filing fees should be the least of your problems. Adjustment of status is only available when people are already in the United States in a legal status. If you are married to a US citizen, you can apply for an I-130 for green card first. Once the receipt of the I-130 comes, you can also apply for K3 visa through the consulate, well actually through the USCIS, unless the consulate takes local filings. And so K3 and green card, whichever comes first, you get it, typically within a year. But AOS is only available when people are inside the United States. Okay. Now, can you come during this time on visa waiver? That's entirely up to the CBP. Customs and Border Protection can refuse to let you enter USA. I wish you were here. I could have dealt with this issue and disposed it off for you, but you're not. So I did the best with what I've got. Next question is Gauresh. My H-1B visa is going to expire in December 2017. Is there any way to start my green card process? Now remember, Gaureshji, your H1 can be extended based upon one of the two factors. So there are two ways of getting H1 extension. One way is based upon time. How long has your green card been going on? And the key number there is 1 year. When your perm is filed, that 1 year begins. You can get 1 year extension once your perm's 1 year anniversary is anticipated. Okay? The other way to get an H1 extension is a 3-year extension. That is when your I-140 is approved. We don't care when your perm was filed. As soon as the I-140 is approved, you are entitled to 3-year extension. Okay? I hope that makes it clear. If you have a follow-up question, press star 5. If you are here, star 5. Anybody has a follow-up question on this? Okay? Oh, there is one. There you are. Let's go to, oh, there are two. Sorry. Let's first go to California. California, go ahead, please.
Hello, Rajiv. This is Rajiv here.
Yes, sir.
So I had a basic question basically. So the thing is, my current employer hasn't started my green card process, and I have not even a year remaining. So if they file for my perm, they can file the perm at any time, right? And,
yes. Yes. Let me clarify something for you.
Sure.
Before, I think 2005, the law used to be, in order for you to get H1 extension beyond 6 years, you should be on H1 when the extension is filed. That is no longer the law. So let us say your perm is filed with 6 months remaining on your H1. Because you don't have 1 year pendency, you'll have to leave USA or go to another status for 6 months. Once that 1 year baking period is over, you can then apply for an H1 extension, even though you're not on H1.
Okay. Okay.
Okay.
Mm-hmm.
Anything else?
So
Yeah.
My employer has to start my green card process immediately.
Absolutely.
Suppose they have only 6 months, even if they file that time.
Yeah.
They wouldn't be able. I wouldn't be able to make my. I wouldn't be in a status basically.
They should file as quickly as possible. That way, even if there is a gap, it won't be too long, hopefully. And as soon as your perm reaches 1 year anniversary or your I-140 is approved, you are back in business.
Okay.
And you're not bothered by the quota because your H1 was approved within the last 6 years. So we are all good.
Yeah. So the base thing is like I need to get my I-140 approved, and then we can file for the H-1B extension.
Or perm pending 1 year, of course. Either one of those situations. Yes.
Okay.
All right.
Sounds good.
Good luck. And also look at curricular practical training through school if it's a legitimate school. That can help some people. Okay.
Okay.
Good luck. All right. Bye-bye. We have 2 more questions. I hope they are related because I'm not taking new questions. Let's go to South Carolina. South Carolina, go ahead.
Hey, Rajiv. Raj here. I'm actually currently working under City of New York. City of New York.
Raj, one second. Raj, 1 second.
Yeah.
Do you have a follow-up question on what I discussed, or is it a new question?
Yeah, just very similar to that.
Go ahead.
I-130 and as well as bankruptcy.
Okay, go ahead.
So currently working at the City of New York with my H1, and I'm still 4 years left to work direct under 6 years. So can I file my GC with another employer because the government is not willing to file my GC?
Yes. It doesn't matter which employer. Let's say you are working with employer X. Employer Y applies for your green card, and when either of the two conditions is fulfilled, 1 year pendency or I-140 approved, employer X can get your extension, H1 extension. So green card is going through a totally different employer, but the benefit is coming to a totally different employer.
So as long as I have a green card processing with another employer, I can still go ahead and do my extensions with the current employer.
Absolutely.
Okay, cool. Thank you.
You're welcome. Okay, we have one more question, and this one is from New York. Yes, New York, go ahead, please.
Hi, sir. I was looking at your website on the chief editor had written something about what I was asking about H4 EAD with the 2 months plus the H4 EAD crossing. On your website, you answered, or you or chief editor, I don't know who would that be? They said that, what do you call it? 1 second, sir.
Take your time.
Yes, sorry.
Take your time.
So it is possible to request a future start date for the H4 status.
Yes.
The hope would be that by the time the H4 status becomes effective, the H4 EAD is also approved.
Yeah.
So the question was, my spouse is currently...
No, hang on.
So you said that-
Hang on 1 second. We had a discussion about that.
Sure.
And since the entry on that document, government has told us, if you put a future date on H4, we will not start working on the EAD until the H4 is approved.
Okay, but even on H1, right, sir, if you put future effective date, H1 is approved before the effective date, right, sir?
Yes, that is true. So
wouldn't that be the case with H4 too?
Yeah, I believe so. In other words, your question is the same as an individual who just spoke with me a few minutes ago. They said, if I ask for an H4 from a future date, the approval will probably come before the future date, right? So then the EAD should follow the H4 approval. And I think, that makes sense. I hope that's the way it works. It shouldn't be that they'll wait for the approval date or the approval effective date before they start working on the EAD. I have no way of confirming it, yay or nay. What I told this gentleman was, I said, why don't you call USCIS? It'll be difficult, but ask to speak with a USCIS officer. Okay? And USCIS is also doing, periodically, they are doing tweets. They have this tweet hour where you can ask them all these questions. And they're usually very good about answering these interspecial questions where we don't really, these are such fine-grained questions that nobody really knows the answers except the people who decide these cases. And I'm not sure they have any well-defined policy covering this issue. Should we start working on the EAD as soon as the H4 is approved? Should we start working on the EAD once the kick-in of the approval date comes in? I can't really comment. I don't know.
Okay. So the entry on your website was done before?
Yes, before the entry on. That's always a danger, and we try to make people aware of it, that we might have entries that have become, every day something new comes up. So it is best to just follow my tweets, follow me on the social media, or just ask me. We do these calls once every other week. So just come here and talk with me. I'll confirm or deny. Whatever I know, I'll be happy to share with you.
And also, you said something about if a company revokes I-140, H4 EAD can be renewed.
No, I didn't say that. I did not say that. What I said was, under the January 17th regulations, which came after the H-4 EAD regulations, there's no doubt that once the I-140 has been pending 180, approved and stays unaffected for 180 days, even if the employer revokes the I-140, your right to keep getting H-1 extensions remains valid. But that right does not spill over to your spouse. For your spouse H-4 EAD, there must be one valid I-140 remaining.
So even if previous employer doesn't revoke it, we should be fine, right?
If the previous employer does not revoke the I-140, then there's no problem. Because as long as one I-140, if you have 10 I-140 approvals, 9 of them get revoked, your wife can still get H-4 EAD approval or extension based upon the remaining 10th I-140.
Is there any way we can find out which 140 is valid or which got revoked? Can we find out from anywhere?
If I were representing you and you gave me 4 approvals, I would put them all with the H-4 EAD.
Okay, so one of them they would.
Yeah, take your pick.
If it's there, it's there.
I can't find out,
Okay.
but that's knowledge uniquely within the domain of USCIS. Let them tell me what is valid and what is not.
But we can find out directly. We can ask them that this is valid.
I don't think there is any way you can do that. You can try filing a Freedom of Information Act request. Sometimes that information is provided. In fact, many times it is. And FOIA is free. You can file one. Why not?
Thank you. Thanks a lot.
Oh, you're welcome. Good luck.
Yeah.
Okay. So the next question is about citizenship. Somebody had to leave USA to take care of their mother who was suffering from cancer, and they stayed away for over 2 years. The green card should have been it should have blown up. It should have been considered to be no longer valid, but CBP allowed them to come in, I'm sure based upon the fact that this was not an intention to abandon. However, as far as I know, naturalization rules work differently. Naturalization rules don't take into accommodation, from what I remember. I can't say that I remember all the rules off the top of my head. My inclination is to say that naturalization rules will only allow you to start counting the 5 years all over again from the date you last entered. So you've got to do the whole 5 years again, and out of those 5 years, 2.5 years you must have been physically present in the United States. Because if you're outside USA for 1 year or more, your naturalization clock gets reset. That's the way I remember the law, but I have not looked at the regulations. Please have somebody do that. You can probably do it yourself, or just contact your congressman. They can find the information free for you. Can you file for naturalization? I don't think so. I think you've got to do 5 years all over again. The 4-year 1-day rule applies to people who have a reentry permit, not to people who went without a reentry permit. If you are here, press star 5. Star 5 if you have follow-up questions on this. Okay. Oh, you are here. Okay. North Carolina, go ahead please. North Carolina.
Yeah, so thanks for your response.
Yes, sir.
I think I don't have any follow-up questions. One of the longest duration I was out was from January to actually Feb 2011 till October 2012 when I came back. So it was close to 20 months, and then since then I've been here. I've traveled for business and personal. But yeah, so in fact, what happened was around 6 months back, I employed a lawyer just to make sure I understand the policies, and he recommended that I can go and apply. I don't know what basis he did that. So I applied for it, went for an interview. The guy who was taking the interview was a very nice guy. He understood everything. Then he said that this point of time we cannot approve. However, I can apply by end of April this year, 2017.
When did you hang on? When did you enter USA? 2012. Yeah, 5 years. Yeah, that's what I thought, that you would have to do 5 years. 90 days less 5 years.
Okay, that's fine. So what wait till April of 2017 and then you apply and you should be able to get it?
I don't agree. I think you would have to wait. You entered back in October 2012. I think you'll have to wait till 3 months. Let's see. In October 2017, you become eligible with 5 years. Take out 90 days from that. That's when you should apply. So October to September, September to August, August to July. Not in April, but in July. Don't take a chance with that, because if you file even 1 day too early, they'll deny it again.
Okay.
It's July, not April.
Okay. Yeah, this was the recommendation that was given by the interviewing officer. I don't know.
They're wrong. They're wrong. I was telling somebody in my, I had a team briefing this morning, just telling the team about the new laws. I was telling them that I'm reviewing a transcript of a grand jury testimony from a very senior investigator who's supposed to be an expert in immigration law, right? And I've read the first 10 pages of the testimony. I've already found 5 legal errors. So you can imagine people who've been dealing with immigration law all their lives still make mistakes about immigration law. So, just because a USCIS officer told you doesn't mean that is correct.
Okay. In fact, he gave me a written note with all the details and the date I should apply. And I have a note, but I think I'll wait.
No, just wait till July. They're wrong.
Okay. I appreciate it. Thank you.
Anytime. Good luck. Okay. Let's see. This is a little bit more complicated. Anik says, after my graduation from a US university, my employer applied for my H1 on April 2010. Approved with start date of October 2010. In December, so you did get the change of status. I'm assuming if you are here, press *5 if you are here, please. Press *5 on your phone if you are here, because I have some questions for you. Okay, you're not here. So I'm assuming that you had change of status. So you got your change of status. That means you are now exempt from the quota. You went for stamping, but you got a 221G. You decided to stay back. So that means October 2016. Okay, all right, got it. You only worked on this H1 for 3 months. Then in October 2014, a company transferred H1B. That was good till 2017, but I could not go for visa stamping. This is a very interesting situation. There are so many variables here. All I can tell you is try going back on H1B without worrying about the quota. But since we are so close to the quota anyway, try first filing under the quota. There are a couple of variables here that are quite bothersome. I'm not sure how USCIS will treat it. You have a very unique situation which is not squarely provided for under the law as far as I know. Okay, so go ahead, because if you apply under the quota and you've been outside USA for more than 1 year, which you have, you are entitled to all 6 years of your H1. That's what I would do if I were you. *5 if there's any follow-up question on this. Okay. Arjun has a question about I-131. Once your reentry permit is filed and you move to India, can you do an update on the change of address? I believe so. Yes, you can. Double check with the USCIS whether you can do a change of address to, because you have the choices are your lawyer can receive the I-131, you can receive I-131 at a US address, or you can pick it up at a US consulate in your home country. So ask USCIS if you can change it. I think you can. After 2 years to keep my green card active, should I visit US once a year? No. Please go through our frequently asked questions. We have discussed this issue in great detail. Green card can be abandoned if you think you can just keep coming a few days every year anytime you get caught, unless your permanent home is in the USA, your green card can be taken away. But you can always file for an extension of the re-entry permit by coming back, staying here before the 2 years of the first one are over, apply for an extension. 1 or 2 extensions should be possible. You're not here, I assume. *5 if you're here. Okay. The last question for the day is, working for my employer from 2010, green card started, priority date is June 2012, my employer is in bankruptcy. See, I have looked at the regulations. Regulations would affect you only if the employer went bankrupt before 180 days of your I-140 approval, after January 17th. So we have to hold our breath till January 17th. Once January 17th is come and gone, I think you're pretty safe. You should be able to get your extension. And EAD, there's no Obama's executive order, this is a regulation. The regulation allows if you have what they call, what was the word? I always forget this. Compelling circumstances. So you can't just apply unless you have compelling circumstances. Okay. There is a raised hand, not sure why, but let's just, oops. Sorry, can you raise your hand again? I'm sorry. Can you press *5 again? Sorry about that. Press *5. Thank you. This is Arizona. Arizona, go ahead. What is your question?
Hello, Rajiv. Thank you for taking my call. Okay, so here is my situation. I have to, process green card for my mother.
Hang on 1 second. Ma'am, 1 second.
Okay.
I have not opened, I wasn't going to do new questions today. We don't have any time. But since you've been waiting so long, I will answer your question. Give me 1 second. Let me open the floor to everybody. Folks, anybody has any questions, stay on the phone. And you are, in any case, you are the first one in the line. You joined the earliest. Anybody has any questions, press *5. 1, 2, 3 people. Okay? These are the only 3 I would be answering. No more questions. 4. Okay, 4 people. All right. 5 people. Okay. I thought it was going to be easier than that. Okay, no problem. We'll take care of it. Ma'am, go ahead with your question, please.
Okay, I'm coming from Peoria, Arizona, and my mother's visa, the visitor visa, is expiring on May 1st. And when she was here with me till last year around November, I had actually processed the green card, like submitting the I-130 form, and it got approved. But due to some circumstances, she had to go back to India. Now, since her visa is expiring, I couldn't, file the adjustment of status. So, do you think if she comes in February, will it be okay for her to enter the country, or would that be a problem?
Okay. Is she currently in the United States, ma'am?
No, actually she's not. That's
Okay.
my problem right now. She's not.
Are you-
When I filed the I-130, she was here.
Hang on.
But,
Hang on. Are you a US citizen, ma'am?
yes.
Okay. Now, the way this works is there are 2 issues here. One is easy. You can actually file for her case to be transferred to consular processing, and within a year and a half she should be able to come with a green card. Okay. The second option is for her to enter on a tourist visa, and they should let her enter. Even the I-130 is approved. It's not guaranteed, but usually they will not stop immediate relatives of US citizens for something like that. But don't have an intention to file for I-485 after she's been here a couple of months. Then start thinking about whether you want to do an adjustment of status for her, because if she enters USA with a preconceived intention to change to 485, it can become a problem. So, oh my God, there's 6 questions. Guys, stop raising hands. No more. I have to go. I've been talking nonstop for over an hour. So please, no more questions. 6 people, that's it. I'm not doing the 7th one. If you raise your hand, I won't take it anymore. Okay, so the problem is if she enters with a preconceived intention, it could become an issue of fraud in using the tourist visa. So avoid that. And if she enters on a tourist visa, I think she'll be allowed to. Don't think about it for a couple of months. Wait and see how it plays out. After a couple of months, maybe even 3 months, start thinking about it. And maybe you can do adjustment of status at that point of time. Okay?
Okay, so she could come into the United States if I can get her a ticket in the next month or so. She could enter because even though the visa is expiring on May 1st, that's okay, right?
Yeah, visa has nothing to do with anything. Visa is simply a permission to board the plane and come to the border.
Okay.
Even if her visa is expiring on May 20th and she shows up on May 19th at the US border, she should be allowed her 6-month stay.
Okay, so after she comes here, after a couple of months, you want me to wait and then do the...
Then start thinking about, have a discussion with her. Don't give her any inkling that you're thinking of having her apply for adjustment of status. She mustn't have a preconceived intention to do so. Okay?
Okay. Well, thank you so much for taking my question.
You're welcome.
Really appreciate it.
You're welcome. Good luck, ma'am.
Thank you.
Bye. Okay, I'm going to proceed to the next 5 questions in the order people had logged in. So let's go to, let's see, this is, which one is this? Let's just go here. This is Missouri. Missouri, go ahead, please. Kansas City, Missouri. You have your hand up, calling from area code 816 on a cell phone. You have to say hello. Okay, I'll leave you open. I'll go.
Rajiv ji?
Go ahead, please.
Yes, sir. Good afternoon.
Good afternoon, sir.
Sir, this is Sharma speaking. I came here on B2 visa to do my certifications. Okay. And I came in the month of March, and I got up to September for first 6 months.
Okay.
After that, I had applied for extension, and I got approved recently up to the March 12, 2013. Now I'm having legal status. Okay. So I got a family here, and my fiance is a US citizen, and she's going to help me to file the green card process.
Yeah, I'm listening.
What's your advice? Because we are it's a Hindu traditional family marriage is happening in the month of July 2017. So what's your opinion?
Well, first of all, the spouse of a US citizen can be out of status and still get a green card if they don't travel outside USA until they get a green card. There's a whole bunch of ifs and buts. I'm giving you the overview. So even if you got married in July and then you applied in July or August for your green card, I think you'll be fine. I don't see any problem with it. As long as
it will be out of status, right?
That's okay. That's okay. Spouse of a US citizen doesn't have a problem. Okay.
Okay,
sir. If you are nervous, you can do another thing.
Yes.
What you can do is listen to me. Before March, you can apply for another extension. And make it clear to the government that you're getting married in July. Don't lie about it. Just say, I'm getting married in July, and then my spouse will apply for my green card, and I don't want to be out of status, so I request 6 more months. While this application is pending, you are not out of status.
Yes, sir.
Okay? And on top of that, this application will not stop your green card or your adjustment of status. So, if you are nervous, go ahead and do that. Okay?
Okay, sir. Thank you, sir.
You're welcome.
Thanks a lot, sir.
You're welcome. Okay, let's go to Georgia. Georgia, go ahead, please. Area code 470. All right. I'm leaving you open. I'll go to Texas. Texas, go ahead, please. Area code 2.
You can hear me?
I can hear you. Yes.
Hi, Rajiv.
Ma'am, can you hold for a second? Let me do 214. Then I'll come to you. Sir, go ahead. 214. Go ahead, please.
Yeah. So, Rajiv, thank you for taking my call. My question I have is, with Mr. Jeff Sessions coming into picture real soon, what are the chances of Jeff Sessions and party revoking AC-21 that came into picture in 2000? And what are the chances they're revoking the regulation that's coming on January 17th? So two separate things. What are the chances of each of those happening?
Jeff Sessions cannot unilaterally revoke any regulations. Jeff Sessions can only go through the procedures that are involved in making new regulations. And by the way, he's not in charge of USCIS. He's in charge of certain elements of enforcement, including deportations, etc. Even there, it's ICE that is involved. Not sure what the role of the Attorney General any longer is, but in any case, for legal immigration issues, his authority is quite limited. While he can influence the government through meetings and suggestions, he doesn't have the power unilaterally to revoke anything.
So let's whosoever has authority, I'm not going to guess, even Mr. Trump has authority, what are the chances of somebody who has authority of doing it once the new administration comes into picture?
See, we tweeted about this a couple of days ago. Somebody was asking me the same question. And I said, once the regulations have been made, they can't be just taken away with the whisk of a hand. Government should have to go through another regulatory effort, which means drafting the regulations, sending them to OMB for approval, going through the notice and comment period. Some of this can be skipped in emergencies, but it still would take some months before anything concrete can be done, and it shouldn't affect people. Let me rephrase that. Let's just stick to that. There are certain things they can affect, but will they be able to take away H-4 EAD without rulemaking? I don't see how. Okay. Anything else?
I think that's it. Yeah, thank you.
Good luck, sir. Ma'am, go ahead. Georgia, go ahead. Ma'am, I could have...
Hi, Rajiv, sir.
Yes, ma'am. I can hear you. Please, go ahead.
My priority date is 2004 EB2, and the status is current now, but before it got current, on the same month I got an RFE on 485.
Okay.
And in the RFE it mentioned as I have refused entries to US with my advance bill, and they asked my current employer letter on the company letterhead, and they mentioned few of the dates which are not correct. Even though I was in US, they mentioned I traveled. So I submitted all the documents almost 6 months back, and in the USCIS case status, it showed after I submitted within a week, it showed they sent a mail for the initial evidence, and I didn't even receive that mail yet. And I called the customer service, and I submitted a request, and I got an automatic mail saying I may receive a mail in December, but I didn't receive the mail yet, and I am worried what my 485 is happening now. And
Ma'am, are you represented by counsel? Do you have a lawyer?
Yes,
Okay. Because this case involves so many specific issues, I cannot give you general guidelines or guidance. You should talk with your lawyers, and if you are not comfortable with their representation, change lawyers. This is not something I can advise you without knowing all the details, exactly what the allegations are, how you have responded. Normally what happens is, if you don't get mail, your lawyer should have gotten mail. Because if they have their appearance on the file, they should be getting the RFE and they should be following up on the RFE. So I'm not really sure what happened here. I can't really give you general guidelines without knowing specifically your case. Tell your lawyers to get involved. I don't think you can manage this by yourself. Okay?
Okay, and one question I have. So in the advance payroll, when we are in the advance payroll, when we apply the advance payroll, we should be in the country, in US, until we get the approval. Is that correct?
Were you on H1 status and you had H1 visa when you traveled?
I went through H1 and I came through EAD in 2007.
When did you leave USA, ma'am?
In 2007.
Okay.
And
So
I came back again after 2 months.
when you left, you had an H1 visa stamp on your passport?
Yes.
And that H1 visa stamp was still valid when you came back?
No.
Yeah, I think your case is doubtful. I don't really know how it's going to work out. I would have to look up the law and the policy. But I think this definitely makes it a little doubtful how it's going to go. Okay?
Okay.
But remember, if the 485 is denied, it can be refiled if your priority dates are still current and you're still maintaining status.
Okay.
Okay? Good luck.
Okay.
All right. Bye-bye.
Thank you, sir. Bye.
Last two questions, guys. Texas, go ahead, please. Texas.
Sir Rajiv, this is Arjun from Texas. This is based on question number 14. So I'm currently in USA with the green card, which I got from my employer. So I applied for a reentry permit.
Hang on, Arjun. I've already answered your question. I'm not going to repeat it.
Okay.
Listen to my answers in the recording. If you have a follow-up, let's do it next time, because you've got to be here on time. I can't repeat the same answers. Okay? Sorry.
Yeah. My follow-up question is, like, when I go back to India, can I apply? I want to get married. Can I apply a green card through consular processing for my wife from India?
Yes, you can.
When I'm in India.
Yes, you can.
And once we got green card, we both can come back to US.
Yes, you can.
Okay, thank you.
Just one thing. Remember one thing. When the time comes for her interview, okay, at that point you should have some evidence that you're in the process of moving back to USA, such as looking for jobs, renting an apartment, because one of the requirements for affidavit of support is that you must be domiciled in the USA, or you must be about to become domiciled in the USA. So when the time for her consular interview comes, make sure you've been applying for jobs and or you have secured an apartment. That would be important.
Okay.
Okay.
Okay. Perfect.
Good luck.
That answers my question.
Good luck, sir.
Okay. Thank you.
Bye. Last question, guys. I don't know who it is. Looks like a voice over IP. Go ahead, please.
Yeah, hi, Mr. Khanna. How are you? I'm Sam from New York calling.
Yes, sir.
My question is, I have applied for EB1, extraordinary ability. I self-petitioned myself, and I recently got an RSE. And the RSE does not mention anything about all the 10 evidentiary criteria that they usually talk about, and they go directly into asking that I should provide how I will continue my employment in the United States, and the Part 2 analysis continues beyond that. So this is the one that I applied almost 9-10 months ago, and at the same time, and I actually applied for another I-140 using the premium processing route. And that odyssey contained, every single evidentiary criteria. Those 10, I have to meet 3 out of those, and I apparently had met only 1. So they had mentioned, what documents I need to provide for each and every evidentiary criteria. Now this one, the regular, the processing that was mentioned like this, that does not mention anything at all about the evidentiary criteria. So I'm just trying to wonder if that has been met, or they are just not addressing at this point. They neither acknowledge that it has been met, nor do they acknowledge that I need to provide any more documentation.
You can't be sure, but going by just common sense and the way USCIS works, the fact that they didn't ask you any questions about the other criteria, means that they are likely to accept those other criteria as having been met, but there's nothing in law or procedure that stops them from sending a second RFE in the same case.
I see.
Okay. So really it's difficult to say.
Okay.
Good luck.
Okay. All right. Thank you very much.
You're welcome.
Appreciate
Bye-bye.
it. Yeah.
Great talking with all of you folks. It's always a pleasure. And I'll see you again in 2 weeks. Thanks for being here. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.